relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're going to bring you the news behind the news in this video blog special. Full Disclosure produces short videos of topical issues on our website, and just like a text blog, we pose survey questions and invite our web visitors to add their own comments to the discussion. We are featuring 3 of these controversial 8-minute segments for you today. Here's our first video blog. Mathematics professor Daniel Gottlieb received an interesting document as a result of a Freedom of Information Act request. It was an application for a loan guarantee from HUD, the U.S. Department of Housing and Urban Development. The application was for a loan guarantee to construct a development in Marina del Rey that Dr. Gottlieb has been fighting for years. He thought the application contained revealing information that should be disseminated far and wide.
And I disseminated it to the press and sent it to many, the Times and fulldisclosure.net, and it got put on the website. And I referred to it in documents myself because I could point out where there were misconceptions, lies, and untruths.
Suddenly he was presented with a very menacing letter ordering him to cease and desist making any and all disclosures, dissemination, or copying of the information disclosed therein. He was ordered to destroy all copies and to report the names and addresses of any and all recipients of the documents. This urgent demand made him wary.
And I thought that they were trying to intimidate me.
And being full disclosure, we sought out the best possible person to explain the sensitive nature of the HUD application. We asked Dr. Richard Fine, who was the former attorney representing homeowners who opposed the developer who submitted the questionable application. He made it very clear why the U.S. Department of Housing and Urban Development was so intent about retrieving this revealing document.
The same people who were involved in the Marina Stand Colony 2 homeowners lawsuit have committed fraud on HUD, the Housing and Urban Development Department, in seeking and obtaining an insurance policy for $125 million to guarantee their loan to put up the New Shores project.
He explained how the application was filled out with the purposeful intent to hide past and current litigation.
There is nothing in here in the HUD reports that talks about the past and present litigation. But we know that the past and present litigation existed and is existing and is currently going on.
The next issue is the money invested. The insurance is to cover the loan. Who is investing in the Delray Shores project?
In all of this, they speak of their various investments and things, but there's nothing showing that these people are putting any money into the project. In Guardian Life, they have Guardian Shores LLC. That's the new 50% owner of the shores. And there they say it's a new entity that has not yet been funded by its parent, Guardian Life Insurance Company of America. And there's no question Guardian Life is a very, very big and substantial company. But there's nothing in here that says that Guardian Life is either going to fund the subsidiary, or second of all, Guardian Life is going to guarantee the subsidiary, or that Guardian Life is going to guarantee the project. So right now you have a skeleton, bare bones project that is sitting here with nothing from anybody saying that this project is going to be going forward, and HUD's out there for $125 million on the mortgage insurance.
So what is the issue here, we ask him?
In summing it all up, what you have is you have the Epsteins, David O. Levine, their management person, the Douglases, and the insurance company, all not giving quote, full disclosure or reporting what they're supposed to report to the government on the application for the insurance, which is a crime in and of itself. Then you have the HUD people not going through and doing the investigation of public records where they would have found all this information, and they would have found the fraud that was taking place on them. So they are actually part of this particular fraud.
We asked Dr. Fine if, after viewing the application, if there was anything he thought should be kept private by the government.
This is public money, and there's nothing secret about somebody applying for a $125 million mortgage guarantee.
So why was HUD so emphatic about getting the application and all the copies of the application out of circulation? Dr. Fine saw no justifiable reason at all.
You have a Freedom of Information request, which is lawful. You have the documents being provided pursuant to a Freedom of Information request, which is also lawful. And now you have somebody coming in and saying, give me the documents back, destroy all the information and everything else. But when you read the documents, you realize that this fraud has existed from beginning to end.
So what was the real purpose of the letter demanding the destruction of all copies of the application, we ask him?
I mean, it's a cover-up. There's absolutely no question about it. And what they are covering up is HUD's both not only incompetence, but its deliberate failure to go out and find the public documents. Or on the other hand, we can speculate that HUD found all these public documents and then hid them.
So we ask him to explain the demand letter from HUD that Professor Gottlieb received.
So the HUD letter that you have is HUD's attempt to cover up the crime and HUD's attempt to cover up HUD's failure to go out and investigate and to illegally go forward and give a mortgage guarantee or mortgage insurance based upon the crime.
So does he really believe that HUD is complicit in a crime, or is it merely government incompetence?
You have a government employee not doing his job, a government employee, and that may not get him indicted, but this letter does. This letter is now the cover-up. Destroy the documents. You know, that's the cover-up. That is where HUD is taking the step too far. And this person who's an attorney advisor, he knows better. This is our $125 million. There's absolutely no reason that that money should be out there based upon what's sitting in these particular documents. Absolutely none. It's no question that there's a fraud that's been committed, there's information that's been withheld. That in and of itself is a federal crime.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, do you believe that HUD is engaged in a cover-up in their failure to investigate the Delray Shores application? Yes or no? Number 2, do you think that HUD and the developer are acting in collusion? Yes or no? And number 3, should the federal government guarantee a loan that has no financing? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. Due to the continuing threats of terrorism, our esteemed authorities are supposedly doing everything possible to protect us in response to a group of radical male Islamists threatening to take over or blow up our passenger airlines. They insist it's necessary to irradiate or grope everyone, including elderly women and children. For some reason, it seems that the only way our clever leaders can protect us from harm is to abuse and punish us, the people. But are they actually doing what is necessary to protect us? Back in 2006, Full Disclosure interviewed gang specialist and former Los Angeles Sheriff Deputy Sergeant Richard Valdemar, who noted a major security lapse in the baggage handling for commercial airlines.
When I was shown the photographs of the inside of the cargo hold, I see all this graffiti, gang graffiti. Not only is it gang graffiti, but rival gang graffiti, where they've been crossing each other out inside the cargo hold, which is very dangerous. You know, I would not only be afraid that these baboons are handling my luggage and fighting with each other in a you know, luggage compartment, but you know, they're going to bring a gun, you know, because there's rivals and they're gang members. They're going to bring guns, and you're just going to liable to have a shooting right there. Then she told me, well, they actually did find a loaded gun on the tarmac. So I said, how did a loaded gun get on the tarmac, you know, in the airport? And then I found out that these people don't pass through the metal detectors like we do as passengers. Because they're airline employees, they were going around the system and handling the planes and the luggage, you know, without being checked. And obviously nobody did a background check on them because they would have found this gang history.
In fact, during an earlier interview with United States Attorney Deborah Yang, she noted the same security issue, the same issue that alarmed Sergeant Valdemar 2 years later.
There was a gap at the airports, and people who had high security badges, so did not have to pass through the magnetometers, and actually had access to the tarmacs and to the airplanes. And so we took a look at all those individuals to see who was properly there and who wasn't. And those who were not, we charged with a crime.
Aha! Our justice system caught the bad guys before they could blow up the airliner. You may wonder why Sergeant Valdemar still found gang graffiti on the interior of the plane 2 years later. Here's why.
As it turned out, some of them, you know, might have been out of status and those types of things, and so we charged them with a misdemeanor, or we just, you know, if it didn't turn into anything, we didn't do anything with them, but they were taken out of their jobs because we needed to tighten security at the airport. There were some individuals that we found had prior convictions that had never been disclosed to us, and so, you know, those were certainly people you would not want to have access to the airplanes.
Now, when you said they were out of status, what does that mean?
It turned out that some of them were illegally here in this country, and so therefore shouldn't hold that type of job, and had indicated on the application form that they were, you know, U.S. citizens or legal residents when they in fact had not been.
These employees, is it possible that they are foreign nationals?
I'm sure it's possible that some of them are. I don't know what background check they did on them, but obviously it wasn't adequate.
In response to our concern that gangs and perhaps foreign nationals could have access to the planes at our airports, we were reminded of the policies as stated by our LA District Attorney. That, in fact, immigration status isn't even considered in their prosecutions.
Hi, this is Sandy Gibbons at the District Attorney's Office for Leslie Dutton. I talked to everybody, you know, our hardcore gang people, and there's no one that can appear on the show. And also, they also agree with me that it would be inappropriate for them to be on a show with a discussion of immigration policies, because our prosecutions don't have anything to do with immigration policies.
Even the feds weren't serious about going after people who were here illegally and conspiring to get access to the tarmacs. If they falsified their forms, does that mean then that you would prosecute them? Or were there instances where you wouldn't prosecute them for falsifying forms?
We could have prosecuted all of them, but what we did is we took a very close look at the individuals. It was a very compelling circumstance. Many people in the community came to me directly to talk to me about the situation. There were certainly, as I mentioned to you, there were certainly ones who had prior convictions, and they were charged with felonies. There were also some people who were out of status illegally here or shouldn't have had that particular position, had falsified the form, but had very compelling family circumstances where they had children in this country, had been living here for a number of years, and so we did what we thought was appropriate and not charged them with a particular crime.
Not believing what we heard, we asked United States Attorney Deborah Yang to clarify what she said. There are circumstances by which people can falsify forms and be in the country illegally but not be prosecuted.
That's right, but they would have to go through an immigration hearing.
Immigration hearing. We sought to get someone from the Superior Court to come on camera and tell us how the court deals with illegal aliens who attempt to subvert our way of life. No problem, according to them.
Jerry and Hazler, the LA Superior Court, calling for Leslie Dutton. And Leslie, you had called about a judge appearing on your program, Full Disclosure, with regard to the undocumented alien situation. And I've talked to a number of judges, and all of them tell me the same thing, and that is undocumented aliens are not treated any differently from anyone else who goes through the criminal justice system.
So we're being asked to subject ourselves to the most intimate searches of our persons and property, while gang members with felony convictions and people who are here in this country illegally are wandering around the tarmacs with impunity. This has been going on for years, and nothing has changed except that we are being required to show what's in our underwear. We want to know what you think. Please respond to our survey and leave your comments and vote below. Number 1. Do you think that baggage handlers and airline employees should be required to at least go through the magnetometers? Yes or no? Number 2. With the historical problems with airport security personnel, do you think that TSA employees have been properly vetted and screened? Yes or no? And number 3, do you think that the lack of law enforcement interest regarding illegal alien arrests and prosecutions have contributed to airport insecurity? Yes or no? Please be sure to vote and leave your comments below. I'm Leslie Dutton. Thank you. On Saturday, October 30th, Full Disclosure hosted our 19th anniversary celebration at the Burton Chase Park in Marina del Rey. Much to our dismay, our guests became victims of the malicious parking policies of Los Angeles County. How many people here had problems with the meters? Look at that. How many people didn't have enough quarters to pay for their parking? And how many people lost money in the meters? Wow. You patting, keep your hands up just so we can be sure that this gets on our home page, because we want the Board of Supervisors and the administrators to see just what kind of public relations they have with people that come from all over Southern California to Marina del Rey and are treated so poorly. Being Full Disclosure, we weren't going to allow this detestable situation to go unchallenged. We asked some of our guests to come back and explain the difficulties that they faced that morning. Althea Shaw explained her trouble.
So we put quarters in, and I put in 4 quarters I had in my purse. I happened to have 4 quarters before anything changed. And then I was like, hey, wait a minute, it's not changing. And so then we pushed the buttons, and then we put a few more quarters in. It still didn't change.
Even our producer, T.J. Johnston, had problems.
Well, I'm trying to run an event as producer for Full Disclosure, so I had to park here and put quarters in the machine. I put in 6 quarters, figuring I got an hour and a half or so I could get in and run the event. And you only get 10 minutes per quarter. 10 minutes per quarter, 6 quarters, that's an hour. That's an hour, and it's a 3-hour event. I had no opportunity to come back out once the event started, so I wound up with a ticket.
Bill Edwards, who also attended the event, was more enterprising. After realizing the impossibility of using the metered parking lot, he drove around the area and found a satellite parking lot that would take a credit card for a longer duration. But he had problems as well.
So I took my credit card, and it says face up, so I put it in, and it says wait a moment please, and then it says unreadable card. So I tried it the other way, and actually I tried to force it in, and then I had trouble getting it out. I thought maybe it was that the sign was wrong and that it shouldn't be face up. It should be the magnetic strip up. I tried it both ways that way. Was unsuccessful to get the card to work. And by that time I was 30 minutes late for the event and parked my car and thought I'd take my chances on a ticket.
Fred Sotilli was victimized by the same machine at the same lot.
I didn't want to pay $8 for 4 hours, but it was my only alternative, so I did. I slid my card into the machine and pressed the buttons. I followed the instructions, and lo and behold, nothing came out. So I thought I had done it wrong, that the transaction didn't take place. So I put the card in again, very carefully followed the instructions, and at the end, 2 cards came falling down. So now I had spent $16 for my 4-hour parking experience, and I was pretty unhappy about that.
We tracked down a county official, Paul Wong, who's the chief of the planning division of the beaches and harbors, and we asked him to demonstrate how the machine should work.
So basically just follow the sign here and insert the credit card face up. If it does not go in naturally, then it's the wrong way. So just insert, and it asks you to choose the payment here, and basically just follow the instruction on how much time you want, and I'll just go ahead and press the blue button for the whole amount here, and the machine will spit out a ticket. You can remove your credit card, and the ticket will be dispensed at the bottom here. It'll tell me that we run out of tickets. Let me try again.
Try again he did. He was determined to demonstrate how simple the process was, with the same confusing result.
I think so. Okay, here it says insert credit card face up. Okay. And down here it says give you option for payment here. Shows Tuesday, November 2nd. And okay, the blue button will increase each payment.
Now this will be your second payment, right?
No, I think it's for the first payment. Earlier, I think I pushed the wrong button.
Oh.
Interesting.
Interesting. Embarrassing. Still, Mr. Wong gamely continued his struggle with the machine.
And the green button here is to validate the transaction and print. So I believe that we did. I did not read the instruction, I believe. Let's try that. So we do the blue button, 6. Okay.
Okay.
I don't know. What happened?
And the public is expected to make this work, or pay a $60 fine. We kept the camera rolling for another assault on the machine.
Let's try it again, and I will just go ahead and... It's paid. Okay. Printing in process, and we have the ticket.
Okay. Hooray! We finally had a legitimate parking receipt. And then we were stunned by Mr. Wong's summation of the exercise. Okay.
So I believe it's quite transparent and clear if we just slow down and read it a little bit.
But then as our producer asked, what is the purpose of requiring the public to go through this extraordinarily difficult process?
Why is the county looking to use meters to soak the public for use of a public park? Why are they soaking us for money in a quarter at a time at a public park where we have the opportunity to enjoy our outdoor spaces that we're paying for through our taxes?
Or is this simply a sadistic revenue-generating process designed to ensnare people who come to the park facility?
Well, sure, it's a setup. It's the easiest thing in the world. It's like sending somebody theater tickets and then going robbing their house when they're at the movie. They know there's an event from 8 or 9 until noon. So come on down at 11:45. They're all inside there. The cars are all here. It's a turkey shoot.
I'd hate to think that the government was so Machiavellian that they purposely make it difficult to actually comply with the law and pay for it in order to get these $60 tickets, which they make an awful lot more money than would from 18 quarters.
Deborah Talbot works for the county. She's the PR marketing director for the beaches and harbors. She defended the parking prices and policies.
There was a study done on that, so they felt that the balance between the free parking during the week would offset that cost, which it costs a lot for us to run these facilities. So there has to be some sort of a revenue source.
Fred Satilli was more direct.
And it's just theft. It's just straight out theft.
And they've really aggravated a lot of folks. So how many of you are in favor of joining a protest to demand that the county fix these meters and lower their prices? Okay, we'll have it on record now.
Well, I think first of all we take hacksaws, saw off the meters, okay, as public, and stand up for our rights to reclaim our park.
Okay, so the county needs the money too.
We do.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, have you experienced these inequitable and confusing parking problems in government-run public parking near you? Yes or no? Number 2, do you think the county is justified in using this method to raise revenue? Yes or no? And number 3, do you think we need a ballot initiative to stop county government from exploiting the citizens who utilize the free public parks? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. This concludes our video blog special. We're interested in what you, the viewers, think. If you would like to answer any of these questions posed by these video blogs, or if you'd like to make comments, please call our Full Disclosure Town Hall number at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
You can watch this program in its entirety as a Full Disclosure subscriber, or you can purchase the DVD on our website. Full Disclosure will continue to bring you the news behind the news.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're going to bring you the news behind the news in this video blog special. Full Disclosure produces short videos of topical issues on our website, and just like a text blog, we pose survey questions and invite our web visitors to add their own comments to the discussion. We are featuring 3 of these controversial 8-minute segments for you today. Here's our first video blog.
I don't advocate legalizing this conduct. I advocate not spending $50,000 a person to put them in prison and make it more likely they'll commit crime again.
According to Deputy District Attorney Steve Ibsen, our prisons are filled with nonviolent offenders who shouldn't be there. And he says our current system of reducing sentences to solve the prison overcrowding problem is counterproductive.
I think the public first needs to understand we're not doing our job. We may be prosecuting people, but when we sentence them to 180 days in jail, if they're not doing that time, they're not being punished. They're learning that crime does pay because there's no punishment. So when you have overcrowding on the scale that we currently have it, we are failing to punish, and that is having a great impact. The criminals know the system is a joke. They know there's no punishment, and that is a great threat to public safety.
His proposal is to stop felonizing nonviolent crimes.
We have trivialized what it is to be a felon by not recognizing the tremendous impact it has after the conviction. And the labeling of a person, the branding of someone a felon should not be the punishment. The punishment should be when the judge says 10 days jail, you do 10 days jail, not 2 days jail. You should do the full 10 days jail and then have a chance not to have a felony conviction if you behave yourself for a year and work hard.
He suggests that the pursuit of felony convictions by the District Attorney's Office isn't helping to reduce crime, which is the ultimate purpose of our entire justice system.
So I think we're being counterproductive with the idea that if we get a conviction, we've done something good. And why have we been doing this? I think it's because people haven't thought about it. I didn't think about it for 25 years. I thought I was doing good. I got a conviction. Look at our stats. Look at how many felony convictions the DA's office had last year, 130,000. We must be doing a great job until you realize, wait a minute, 130,000 people are now felons. When they apply for a job, their application says felons. It's harder to get a job. And then you say, we've got 12% unemployment. You've created unemployable people. And that's part of our unemployment problem. Just as if you cut the legs off of 130,000 people, they're unemployable.
Mr. Ibsen gave a specific example.
Last Thursday, a young person, possession of marijuana for sale. And there's no doubt this person was guilty. The police officer or the deputy sheriff stopped them, and I think the person had a few bindles of marijuana, and they admitted, I lost my job and I was selling it. So they admitted that. No prior criminal record. What our office is doing, and we think is sort of a lenient sentences, 30 days, 60 days, 90 days in jail, 3 years felony of probation. In reality, that person will perhaps do a week or 2 weeks in jail, very little time, but they end up being a felon for life because possession of marijuana for sale is a lifetime felony that can't be reduced, can't be expunged from your record. So what I ask my friends now is, now this person is a felon for life, is it going to be harder or easier for them to get a job? And it's obvious it'll be more difficult. Every job application asks if you have a felony conviction. So we've just taken a 19-year-old who's absolutely committing a crime. I don't approve of marijuana use. I don't approve of marijuana sales. I consider that person dealing drugs. They, with certainty, have committed a crime, which in California is a felony. Now it's more difficult for them to get a job. Is it now going to be more or less likely they'll commit another crime? And I think it's pretty clear it's more likely they'll commit another crime. And that's part of the path towards recidivism.
The difference in his proposal is realigning where the aim of prosecution should be focused.
We are going to prioritize public safety, and that the people that we're putting in prison or in jail are going to be those that compromise your safety. The public also needs to know that these public welfare crimes, that possessing drugs for sale or shoplifting is not going to be tolerated, but we have a different approach. And that, I'll call that reform first, which is you will be arrested, you will be incarcerated, any sentence you get will be a real sentence, and that's truth in sentencing, but we will give the person an option. If they want to plead guilty and work for an entire year, that they can avoid incarceration because their punishment is hard work and paying taxes.
Mr. Ibsen gave an example of how he's implementing reform first right now.
I have 2 individuals right now, and I have a number of people I've done this with, but one is a young couple in their 20s, no prior criminal record, and without a doubt they were drug dealers. They had, I believe, 40 pills of some sort they were selling, and marijuana. Their phones had text messages, for sale and orders they were placing. That was their economic enterprise. That was their business. We like business. Selling is good. Sales is a great occupation, unless it's drugs or stolen property. So the desire by human beings to sell things and get money is a good one. When it's drugs, we need to discourage it. So with these two, I made them that offer. They came back a month later, both with jobs at Hometown Buffet. My view is that they're not drug dealers. No drug dealer is willing to work at Hometown Buffet clearing dishes and scraping dishes and cleaning up and vacuuming Hometown Buffet in order to avoid the label of being a drug dealer. These two could have done a week or two in jail, accepted the label of drug dealers, and been done with it. But instead, they had a desire to avoid that path in life. And so by my definition, they're not drug dealers. Drug dealers don't do that.
Reform First makes the perpetrator responsible for either working off the felony for an entire year with the threat of a substantial prison term if there's another offense, or taking the easy way out with the usual discounted sentence and the felony label. Apparently, real criminals don't mind the big F label.
So in my judgment as a prosecutor, the mere fact that they did sell drugs and possess drugs for sale doesn't mean they're drug dealers. The fact that they would choose to work for an entire year scraping dishes, clearing dishes, and vacuuming the floor at a Hometown Buffet demonstrates that though they committed the crime of a drug dealer, they don't want to be drug dealers. And unless we brand them, limit their economic options by making them unemployable as felons, they're likely to reform. And if we reform them first, it's a lot cheaper. We don't have to house them in prison at $50,000 a year using our tax money. We can use that money to house people that commit robberies, people that assault our families, people that invade our homes that currently are that we don't have enough jail space for.
But these people are being arrested for what society believes is a felony. Aren't they getting away with their crime?
To the degree that they're not being sent to jail for possessing marijuana for sale, I guess you could say they got away with one. But I think that they got away with it in the sense that they decided to put themselves at risk and face state prison time if they failed in this opportunity to conform their conduct. And I think we benefit far more by giving them the chance to reform first than demanding punishment in every case. So,
his Reform First puts the burden on the perpetrator.
We just need to slow down, look at people one at a time, look at their behavior, give them an opportunity, and if it doesn't jeopardize our family safety, let them out of jail and say if you work and you behave yourself, you won't be a felon. If you let us down, then you'll be sending yourself to state prison. That is what I think is the solution at this time.
We want to know what you, the viewers, think. Please respond to our survey and be sure to leave your comments below. Number 1. Do you think this is a solution for our prison overcrowding problem? Yes or no? Number 2. Do you think it is a good idea to allow people who have committed non-violent felonies a way to avoid being labeled as felons? Yes or no? And number 3. If Mr. Ibsen puts his Reform First proposition before the voters as an initiative, would you support it? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you.
When government is pressured by money concerns over public safety concerns, very scary things happen.
Scary indeed. Deputy District Attorney Steve Ibsen is seeing that due to severe budget deficits, convicted murderers are being released back out on our streets.
It is becoming increasingly prevalent, both the parole of murderers and the request for a compassionate release of people who've been even recently convicted of murder, and there's a reason for that, and it's a disturbing reason, and it goes back to what we've discussed since I think back in 2006, 2007. You've been focused on is the overcrowding problem in prisons.
In 2009, a panel of 3 federal judges decided that overcrowded conditions in California state prisons are so bad that the state must release between 35,000 to 40,000 inmates. Their judgment was that the overcrowding had come to the point that conditions became unconstitutional, meaning they violated the Eighth Amendment's ban on cruel and unusual punishment. The California Department of Corrections and Rehabilitation is caught between a rock and a hard place.
The state law is very clear that you can't release anyone before the 50% mark, and they've been following that. Unlike county jails, like our Sheriff Baca, who is releasing people at 10% time or 20% of their time, so they do virtually no time. The state has been very good about, for all crimes, whether it's selling marijuana or bouncing a check or stealing a car, they're in there for 50% of their time. There's nothing they can do to alleviate the pressure in the state prison system except one area, and that's the life inmates, and that's murderers. So that creates a real problem where you're under a federal injunction saying you've got 40,000 too many people, you've got huge expenses of incarceration, and you have a budget problem. So our budget problem and our over-encrowding problem and the federal injunction has created a situation where the only way the penal system can save money is releasing murderers, which is a huge problem.
No kidding. To illustrate this, Mr. Ibsen gave a personal example.
2 weeks ago, I got a motion for a compassionate release, and it's the first motion I've gotten in 25 years of a murder, and I was surprised initially that this was a murder convicted in 1994 of a estranged boyfriend murdering his ex-girlfriend's new husband or new boyfriend. And the parole board under Marsy's law, that I was co-author of, just a year ago denied him parole for 10 years. And they documented the numerous violent attacks he had on the prison staff and his continued dangerousness. And then we get a compassionate release request, which can go to the court, and they can let a convicted murderer out where parole's been denied. They're supposed to be in for life. They still have 10 years before their next parole hearing, and there's a motion sent to the local judge and the prosecutor. And reading this motion was chilling, and what it said to me about the desperate desire to save money because of our overcrowded prisons. It costs a lot of money to keep people in who are lifers, people who are on death row, especially with medical problems.
We asked him to explain what compassionate release is all about.
There's a compassionate release provision in the penal code that's important, and it reads that if the person, the inmate, is in a comatose state, if the person is in a vegetative state and death is imminent, or if they are so physically disabled that they're of no threat to public safety, they can be released on compassionate release to expire in a facility. I think judges and prosecutors in very few cases are comfortable with that. If it's coma you can come out of, you don't want to do a compassionate release because there's no mechanism to go back in. And so you have to be very careful before you ever consider it.
So compassionate releases are irreversible. Once out, the murderer is out until they re-offend, and this is now a growing trend.
But I understand there is a significant explosion of these requests, and the case I received causes me huge concern that the pressures in the state prison system now, the economic pressures, are being released in the only place they can. It's sort of like if you have a brain hemorrhage. That pressure is building up and in the blood vein, and when it bursts, the damage it does is incredible. And so what doctors do is, how can we alleviate the pressure before the damage is done? And so that's why it's so important to alleviate the pressure in our criminal justice system in a way that doesn't harm public safety. Otherwise, that pressure goes the only way it can go. And right now, under the law, the only area that legally the CDCR, the California Department of Corrections and Rehabilitation, can legally release people earlier than 50% are murderers. The solution is not on the side of what do you do with the most serious and violent and dangerous offenders? Should we release this one person or not? The solution is on the side of, is the criminal justice system properly handling cases on the district attorney level, on the court level, and can we do a better job to make sure that those that threaten our safety are incarcerated to the extent and time they need to be incarcerated without early release so that they know there's a credible punishment.
In other words, people who pose a danger to society deserve to remain in prison as punishment for their crimes of violence. Those who aren't a danger should be remanded to some kind of rehabilitation or restitution program. Without this realignment of priorities, the decision of who will be released will be left to the Department of Corrections.
The Department of Justice and the California Department of Corrections and Rehabilitation is not in a position to deal with their overcrowding problem. The problem is created in the court system and with the district attorney of every county that is failing to properly prioritize what crimes are prosecuted, how they're prosecuted, and make sure that those incarcerated present a threat to public safety. And a modification, a relatively simple modification and change of our approach, focusing on dangerous offenders being incarcerated and others with an effort to reform them before their conviction takes place, can deal with the overcrowding problem by dealing with the least dangerous offenders rather than releasing murderers.
The current trend by corrections and parole to reduce the overcrowding problem is dangerously misguided.
We're looking at, I'd say, absolutely the wrong side of the equation. We can't solve it by deciding which murders are released.
We want to know what you, the viewers, think. Please respond to our survey and be sure to leave your comments below. Number 1, do you think that murderers who are sick and dying should be released in order to save money? Number 2, do you think that prison overcrowding is a cruel and unusual punishment for murderers? And number 3, do you think that dangerous murderers can be rehabilitated? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you.
Well, I think the Times endorsements are basically wrong.
On Sunday, October 10th, the Los Angeles Times came out with their voter guide. And in this guide, they broadly endorsed the confirmation of the Supreme Court and the 2nd District Appellate Court judges and the candidates for Superior Court. As a casualty of fighting the judges in the LA Superior Court, Dr. Richard I. Fine was recently released from the Los Angeles County Central Men's Jail after surviving over 18 months in solitary coercive confinement. Dr. Fine knows the real inside story on California judges. He takes issue with the Times endorsements.
We know that the California judicial system is dishonest because of the fact that after the Sturgeon decision, the Judicial Council of California, comprised of the judges and others, the California Judges Association, and the Los Angeles Superior Court got together to draft Senate Bill SBX 211.
In an unprecedented act of legislative deceit, Senate Bill SBX 211 granted retroactive immunity of all the judges who had been taking payments that were prohibited by the state constitution. SBX 211 granted the judges immunity from criminal and civil prosecution as well as judicial discipline.
But most important is criminal prosecution, because that means that they got immunity from criminal prosecution for basically theft and misappropriation of funds.
Representing Judicial Watch, Paul Orphanides was one of the litigators who won the case, Sturgeon versus County of Los Angeles, where the court held that indeed the payments to the judges by the counties were illegal. He agreed that there was something wrong with the LA Times endorsements. When a newspaper like the Times endorses those, shouldn't they also report the fact that these judges received immunity from criminal prosecution?
Oh, absolutely. The fact that the LA Times chose not to report on that, I think, questions any endorsement that they gave. It puts those endorsements into question.
I'm not in the head of the LA Times or their editorial board, but the LA Times, I can only speak of history. And I can tell you from the time that Senate Bill SBX 211 was passed, which was February 2009, through the present, to my knowledge, I do not recollect any time that the LA Times has actually mentioned SBX 211 and the retroactive immunity. As I say, I don't know the reasoning, but possibly, I will speculate at this particular point, that the relationship between the LA Times and the judiciary may be of such a nature that the LA Times is so close to the judiciary that it is afraid or does not wish to criticize the judiciary.
And this is not the first time the LA Times has come out with their suspicious endorsements. Full Disclosure obtained this list, which was researched by private investigator Clark Baker, LAPD retired. This list shows endorsements of judicial incumbents by the LA Times all the way back to 1988, when these illegal payments started. For some unexplained reason, only the LA Times is reluctant to expose this issue.
On the side of the Sacramento Bee and the LA Daily News, you have guts and courage in the reporting. And on the side of the LA Times, you have a total cover-up. And then even worse, a statement saying that we have an honest judiciary, when obviously the board the editorial board of the LA Times and their reporters know that you have SBX 211 sitting there and retroactive immunity.
Dr. Fine has witnessed the biased handiwork of the Los Angeles Times for years. It became obvious during his work on the Marina Strand case.
So what happened with the LA Times is the LA Times was doing everything to try and make the judge look good. Now, as it turned out, Judge Yaffe resigned from his office. And he resigned from his office after I reported him to the Commission on Judicial Performance for obstruction of justice and numerous other, and taking the payments. Once I did that, he left.
Most people aren't aware that the Los Angeles Superior Court judges are taking payments that are prohibited by the state constitution. Could it be the reporters from the LA Times were ignorant of the fact that the judges were actively participating in obstruction of justice?
The obstruction of justice pattern was shown in the Marina Strand case, which the Times was covering. I showed that as part of the Marina Strand case because I told Judge Yaffe in the Marina Strand case that I said, Judge Yaffe, you're taking illegal money. Judge Yaffe responded by throwing me in jail for contempt of court. And in fact, when Judge Yaffe released me, he stated in the release order that one of the effects of my being in jail for 18 months on contempt of court was to deter other people from doing the same thing. He used the words on the facts of this case, meaning the Marina Strand case. And what were those facts? The facts were that I challenged Judge Yaffe for being on the take.
Sterling Norris is the lead attorney from Judicial Watch, concerned about corruption in the California judicial system. He has been struggling for years to get information to the voting public so that we, the people, can rectify the situation.
Yeah, what you need to do is have some way of getting the truth to the people. They can vote the ballot box if you do, but you've got to have some kind of a system. And of course, the judges will fight that tooth and nail. Don't you dare publish my sentences.
But according to Dr. Fine, we can't expect the Los Angeles Times to be of any help in exposing the corruption.
So the LA Times has a history of not reporting the problems with the judiciary. And all the stories that the LA Times did about the Marina Strand case and me, they never reported about SBX 211 and the retroactive immunity. And I called their reporters on that. They did nothing. Absolutely nothing. So I can't tell you what is in their head, but I can tell you what their actions were. And their actions were that they knew about it, but they never reported it.
Dr. Fine is taking the matter in his own hands. He's challenging the incumbent judges and the new judicial candidates to come clean.
From now to November 2nd, I am issuing a challenge to every judicial candidate, from the California Supreme Court to the California Courts of Appeal to the Superior Courts, to debate me either in this studio of Full Disclosure Network or anywhere else, to defend themselves as to why they have the integrity to be a California judge when they have received retroactive immunity from criminal prosecution for having taken illegal payments from counties. I will meet you here or anywhere else. The challenge is on. I await your response.
Being that we are Full Disclosure, it's important to know that we requested an interview with Nicholas Goldberg, the editor of the opinion section of the Los Angeles Times. He responded that he's not going to be available to appear in this video because they're short-handed right now. We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1. Do you think the LA Times endorsements of the judges have any credibility? Yes or no? Number 2. The courts have ruled that these payments are illegal. Do you think judges should return the money and be prosecuted for their crime? Yes or no? And number 3. Do you think that the judicial candidates should declare in their campaign statements that they will not take the illegal funds? Yes or no? Please respond to our survey and be sure to leave your comments below. This video blog is only a small portion of an in-depth expose on judicial corruption and the LA Times, soon to be released on DVD and streamed from our website. I'm Leslie Dutton. Thank you. This concludes our video blog special. We're interested in what you, the viewers, think. If you would like to answer any of these questions posed by these video blogs, or if you'd like to make comments, please call our Full Disclosure Town Hall number at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
You can watch this program in its entirety as a Full Disclosure subscriber, or you can purchase the DVD on our website. Full Disclosure will continue to bring you the news behind the news.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're going to bring you the news behind the news in this video blog special. Full Disclosure produces short videos of topical issues on our website, and just like a text blog, we pose survey questions and invite our web visitors to add their own comments to the discussion. Here's our first video blog. After Judicial Watch won their appeal in the case of Sturgeon versus Los Angeles County, the Los Angeles Superior Court judges got one of their buddies to rule in their favor so they could keep their illegal $57,000 in annual payments. Once again, Judicial Watch took their appeal to the California 4th District Court of Appeals. Full Disclosure was there to record the oral arguments in what has become known as Sturgeon II. Representing Judicial Watch, Sterling Norris clearly laid out their reasons for their appeal.
The first being that the extra did not fit the extraordinary session, didn't fit the language. The second one is what I call Sturgeon I, that there's a violation of the standards and safeguards of that. And thirdly is the equal protection argument.
The three justices seemed to challenge the arguments advanced by Judicial Watch.
There are numerous benefits. I think all parties pointed that out in their briefs in the first rounds of briefing. You know, every county, some counties pay out of their court funds, some counties pay directly.
Does the legislature have the legal authority in prescribing judicial salaries to prescribe different salaries for different counties?
We didn't say that there could never be variation in compensation.
The issue was Senate Bill SBX 211, which was passed in February of 2009 during an emergency session of the California legislature as part of the budget crisis. The bill was slithered in by the Judicial Council very quietly in the middle of the night while everybody was yelling and screaming about the budget, so nobody heard about it. It was quietly passed and signed by the governor without discussion. And it immediately gave retroactive criminal immunity to the judges for having taken the illegal payments for the past 20 years. These payments, the appellate court had declared unconstitutional back in November of 2008 in the case Sturgeon versus the County of Los Angeles, or Sturgeon 1.
I think, Your Honor, to implement what Your Honors have declared unconstitutional, to come back with a legislative fix for LA County is not the proper thing to do.
The Honorable Appellate Court Judge Tricia Benke was the presiding judge at the hearing. She questioned Mr. Norris about the propriety of the legislature considering SBX 211 during a special session supposedly called to hear the budget issues.
The special session, did that go properly? Was it proper? And
no.
Well, the proclamation was proper. The question is whether or not what they did with regard to compensation fit within that. And your response would be no.
Yeah, but if Your Honor's question deals with the extraordinary session, and certainly the section of that session said in the proclamation of the governor to consider and act upon legislation to address the economy, including but not limited to efforts to stimulate California's economy, create and retain jobs, and streamline the operations of state and local government. And if one can stand up with a straight face and say, Sturgeon comes within that purview, I suggest that it cannot, it is not common sense, and it should never have been considered.
Jones Day attorney Elwood Louie was an appellate court justice. He's now representing LA County. He was trying to maintain the extracurricular payments to the judges. He defended the passage of SBX 211 without any reference to amending the California Constitution.
Well, I think you could try to say it was quite alarming to many judges throughout the state of California that we had Sturgeon 1. And so we want this court,
it was very disruptive.
This court specifically said it's not an onerous task. The legislature can address it. And as Michael Jordan used to say in his Nike commercials, just do it. Well, that's exactly what the courts and the legislature got together, and they passed this act. The governor approved it and was signed.
Sterling Norris provoked an interesting question from Justice Neres.
What language would you suggest be used to have the state of California focus on this issue and resolve it?
I would say that find XB 211 unconstitutional, based on Sturgeon 1, that you have no fundamental policy, you have no safeguards, and make them come back with that.
Apparently the justices didn't feel that motivated. Justice Nares proposed delaying their decision.
I wonder if we should withhold issuing an opinion for a while and see what happens.
He is suggesting that the court could dodge the responsibility in hopes that the immovable California legislature could possibly figure a way around this mess. It's apparent that the judges really don't want to cause any more disruption, as Justice Benke described it. Apparently, they've taken a lot of heat since ruling against the judges in Sturgeon 1.
I don't think this is the last. I foresee a Sturgeon 3 coming down after legislature acts. And I'm sure we'll see all of you again.
After the hearing, we interviewed Mr. Norris to get his response to the delaying tactics. Talking about a Sturgeon 3, did that kind of, were you expecting that they were going to drag this out that long?
They will try to drag it out and try to drag it out. And it all depends really on the strength of the judges who make the decision.
He was incensed that the court didn't appear to want to act on this appeal. We asked him what he really wanted from the court.
I was asking them to declare it unconstitutional. And they were dragging on about, well, how long do we wait for the legislature to act? I'll tell you how long it will take them to act. If you declare it unconstitutional, tomorrow there will be action.
What ruling did he think he was going to get from this court regarding SBX 211? We asked him.
They could piecemeal, uphold certain parts of it, declare other parts unconstitutional. But we'll just have to see.
Paul Orphanides, the Director of Litigation for Judicial Watch, accepts the fact that this issue isn't going to be resolved in the near future. The LA judges won't give up their extraordinary bonuses without a prolonged and protracted fight. Being funded by the court, they'll never run out of money and resources to hire the top litigators in the nation to continue the fight all the way to the Supreme Court. The comment was made that this might end up with a Sturgeon 3.
Sure. I think that was one of the justices who made that comment.
And what does that mean?
I think it means the judge thinks it's not going to be over whatever decision the court makes today. There could either be an appeal to the Supreme Court, and I expect either party, either side, win or lose, what's going to happen is they'll ask the Supreme Court to review this court's decision. But the other idea is there'll be additional litigation, either in the context of this particular lawsuit or another lawsuit that will be filed.
We asked him how long this court will stall before they rule on his appeal. He was optimistic.
We expect a ruling. It could be, within a matter of weeks. It could be a couple months, but in the not too distant future, we should be getting a ruling, and then we'll see what happens there.
Sterling Norris thought the whole issue of the Los Angeles Superior Court judges demeaning their office by squabbling over money was reprehensible. But apparently, if the amount of money involved is great enough, even so-called honorable judges will get their robes dirty.
That they got this money that should never have gone there, and they continue to draw those benefits at excess. Right now, $50,000 more than any other state judge, and with their state salary, they're the highest paid trial judges in the nation.
But Mr. Norris was hopeful that the appellate court judges would be more honorable.
I would hope that they would stay in the spirit of Sturgeon 1 and do what they should do and very simply declare it unconstitutional.
We here at Full Disclosure want to bring to light a couple of issues that aren't being addressed by either party. The California State Constitution sets forth that all Superior Court judges are employees of the state of California, and compensation and benefits are to be paid by the state. Senate Bill SBX 211 attempted to change the Constitution by declaring payments from LA County to the judges are illegal without amending the Constitution. Amending the Constitution requires a vote of the people. Another question that begs attention is, under what authority can Senate Bill SBX 211 provide retroactive criminal immunity from prosecution to the judges? These judges who have accepted some $300 million in payments that were forbidden by the Constitution. There are laws prohibiting ex post facto laws. Immunity is something you grant to a party before an act is committed, not afterward. Why is it that no one is discussing these very significant concerns? I'm Leslie Dutton, and we here at Full Disclosure will continue to bring you the news behind the news. Thank you.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At fulldisclosure.net, we want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show. And if you can't watch us on your local cable station, streaming video of complete shows when you want them. Fulldisclosure.net, when you need to know the news behind the news.
It's 5 down, 425 to go, and I will take them down the line if I have to go through 425 judges. That's exactly what's going to happen.
Dr. Richard Fine is looking for one honest judge to nullify the order that put him in jail for 18 months.
Under what we call California Code of Civil Procedure, Section 473, D as in dog, a motion can be brought at any time to set aside a void judgment. That's the motion that I have been bringing since August of 2010.
He was jailed for not complying with Judge David Yaffe's order to pay a $47,000 penalty fee, which Dr. Fine insists Yaffe's judgment was void.
The reason that the judgment is void is because Judge Yaffe was on the take. You know, he took, I think it's $860,000 of money from LA County, who was a party to the case. That makes his judgment void. It was a bribe. Under ordinary circumstances, he would have been thrown out of office. That is what should have happened to Judge Yaffe.
But what should have happened didn't happen. What was the result?
Every order that Judge Yaffe made was void because of the fact that he took that bribe.
And so Dr. Fine has been trying to get a fair hearing in the Superior Court. 4 judges so far have found a variety of reasons to stop him. We ask him, what is the current status of his case?
Suddenly we have this new judge, Judge Kuehl. Now, Judge Kuehl then comes out with an order saying that all judges are elected officials and no elected official can overrule or decide what another elected official has done. Well, that's total craziness. Number one, there is no law that says that. This is something that she either made up in her head, or it is something that the judges are tending to use when they don't want to make a decision. In fact, it is even against the law.
Dr. Fine gave us a copy of Judge Carolyn Kuehl's order.
So consequently, we'll put it up and let the world see what craziness and stupidity these people are now acting with.
Why are the judges going to such lengths to prevent Dr. Fine from nullifying Judge Yaffe's order?
They know that any order by a judge who has accepted illegal money or any money from a person who is likely to appear in front of them is void. Now, what that means is that any money that any judge took from LA County, where LA County is either a party before them, or LA County is a witness before them, or LA County was likely to appear before them, is going to be void.
This statement has wide-ranging consequences.
That means that every case where any of these possibilities happened, you have void orders and void judgments. And when you have a void judgment, there is no time limit. as to when that case, that void judgment, can be set aside. So it is up to the lawyer or the individual to come in and have it set aside.
We ask him, does that mean that anyone who has found themselves on the losing end of a case in LA County can come back to court and move to have that order or that judgment set aside, wiped clean, erased, nullified?
That is correct, and I'm putting the word out right here and now and encouraging every person to use their rights and go forward and do this, and to ask their lawyers to do it. And if the lawyers don't do it, the lawyers will be violating their duty to their client to adequately represent their client.
That means if someone has been forced to pay a fine, the county must refund that money, no matter when the fine was imposed, or no matter how much money was involved. Once the decision is voided, is there restitution?
Well, once the decision is voided, that means that the decision never took place. And so consequently, if somebody got, the money, or if the county got money from a person, the county's going to have to give that money back because they don't have a right to that money because the court never had jurisdiction to make the award.
Dr. Fine is leading the charge to restore integrity to our judicial system. He says it's up to us. As shown by his particular case, nobody else is going to do it.
The responsibility is now going to fall on the individual people because we've had a total failure of government.
During his incarceration, Dr. Fine sent appeals to all levels of the court and law enforcement to stop the corruption, all to no avail. It's now up to us to reclaim our justice system.
So as much as our government officials have decided to lay back and do nothing, and shall we say scratch each other's backs and stick it to the people, the method is there for the people to do things. And if we the people go forward and exercise our rights, sooner or later we're going to win.
Dr. Fine is offering his guidance to help everyone who's been victimized by the California court.
Every person who has been the subject of a void judgment can now come in under CCP section 473D and ask to have the order or the judgment set aside.
We asked him if he would make his filing available as a template here on our website to make it easy for people to file to have their case nullified.
Absolutely, it's a model. Someone could go in and use it as a format and go in and do it.
Once again, he emphasized that everybody who has lost a case in the LA Superior Court in the last 20 years can file to have their case nullified.
You're talking about every case where LA County is involved, from eminent domain cases to cases where the county is a plaintiff or a named plaintiff or a defendant, to family law cases where they're using county people with respect to children, to decide custody of children, where they have the county being the evaluators because Title IV money goes into the county, and you have the county being intimately involved in these custody decisions and child support decisions, all the way into criminal cases. Because you have the county coming in, you've got the sheriff's department coming in and testifying in the criminal cases.
He has shown the way to reverse the corruption for the last 20 years. All people need to do is follow his example.
People will have a path to follow. Then people who want to follow that path and who really want change will be able to exercise their rights and take that change. It's the old thing that you can lead a horse to water, you can't make the horse drink. All people who sincerely want to have change will do something about it. hopefully my contribution is that I have shown them a path to be able to get around the intransigence of the judges, the intransigence of the Attorney General and our local U.S. attorneys, the intransigence of the Jerry Browns, who've been the state attorneys generals, and the Coolies, who are the district attorneys. All these people have stymied us. But that hasn't stopped us. And my contribution is to show the path. Now that path is available for people to take it. And if they want to take it, and if they want change, and sincerely want change, it is now easy to accomplish. There is no longer the excuse, oh, it's too hard, what are we going to do, I can't afford the attorney, or the attorney won't do it. Those excuses are gone. Now we have a very simple way of doing it. You bring a motion to set aside a void judgment. And the reason for the motion is the judge was on the tape.
Dr. Fine explains the simple process of how to use his template.
You go to the county, you get the amount of money that the judge has received, you plug it in, and away you go. It's as simple as that.
Dr. Fine is continuing to implement his own template to further his case.
I just file a notice of resetting the hearing, and I will reset the hearing in Department 85 because I've been informed that Department 85 illegally never moved the file to Department 1. So I'll reset it in Department 85, and I will demand that it be heard by a judge who has not received any money from the county. If they give me a judge who's received money from the county, I'll immediately have him or her disqualified, and we will just keep going. And I'll just knock them off judge by judge by judge by judge. Sooner or later, we're at 425 now. Sooner or later, we will be down to 0. It's as simple as that. I mean, it's mathematics now. It's just a question of how long it'll take. But in the end, I will prevail, and we will prevail.
But the judges aren't just going to roll over and give in to Dr. Fine.
So they have an interest, and a very, very major interest for both their jobs, their financial security, and their freedom to do everything they possibly can to stop me from enforcing the law and getting Judge Yaffe's void order set aside.
Dr. Fine is playing hardball with the judges, who are among the most powerful people in our society. It's a wonder that he is so optimistic about his chances of getting the judges to relent.
I have no doubt sooner or later I will prevail. It's just a question of how long I live and how long they stay in office. That is really the clock that we're dealing with. And my father died at 96 in his sleep. I'm 71, so I've got 25 years to go. I don't think they've got 25 years left. Any of these judges have 25 years left on the bench.
Dr. Fine has been fighting the judges for 10 years. They have destroyed his finances, taken away his livelihood by disbarring him, and jailed him for 18 months in the solitary coercive confinement in the notorious Los Angeles County Men's Central Jail. As shown by every appeal he filed while in jail, the corruption seems to infect every level of our justice system, all the way up to our U.S. Supreme Court. That is what Dr. Fine is opposing.
On the other side, you have little old me, who is going to keep coming. If you go back to Butch Cassidy and the Sundance Kid, and they keep looking at the people that were coming after them, and they say, who are these guys? I'm those guys. I will keep on coming and keep on coming. And we have 430 judges. We've knocked off 5 of them. It's 5 down, 425 to go. And I will take them down the line if I have to go through 425 judges. That's exactly what's going to happen.
He ended his interview with a meaningful analogy.
As far as the judiciary is concerned, it's no longer a dying animal. It is a dead animal. It is just a question of removing the carcass.
Full Disclosure will provide you with the contact information where you can find out how much your California judge has been taking from LA County. And if you decide to disqualify your judge and null and void the judge's order in your case, please send a copy of what you file with the court along with the case number to Full Disclosure at the address below so we can follow your case. Please let us know what you think. Is it time for the citizens to join with Dr. Fine and hold the judges accountable? Please be sure to leave your comments below. This concludes our video blog special. We're interested in what you, the viewers, think. If you would like to answer any of these questions posed by these video blogs, or if you'd like to make comments, please call our Full Disclosure Town Hall number at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
You can watch this program in its entirety as a Full Disclosure subscriber, or you can purchase the DVD on our website. Full Disclosure will continue to bring you the news behind the news.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're going to bring you the news behind the news in this video blog special. Full Disclosure produces short videos of topical issues on our website, and just like a text blog, we pose survey questions and invite our web visitors to add their own comments to the discussion. We are featuring 3 of these controversial 8-minute segments for you today. Here's our first video blog. Full Disclosure's coverage of Dr. Fine's 18-month-long incarceration in jail played a significant role in getting his freedom. We think it's important to give you an update on his current battle to restore integrity to our California justice system. The major climax occurred with Dr. Fine's confrontation with Judge David Yaffe. You attempted to disqualify Judge Yaffe.
I actually did disqualify him, and he didn't get off the bench. He stayed on even though he was disqualified, so he broke the law. And that means after he did that, everything that he did in that case was void and null.
On March 10th, Dr. Fine will be headed back to court to continue his struggle to null and void all of Judge Yaffe's orders. To date, 3 judges have fallen to Dr. Fine's sword. In October 2010, Yaffe resigned. Earlier this year, Judge Ann Jones recused herself from hearing Dr. Fine's motion. And then Judge O'Brien dodged Dr. Fine by refusing to schedule the hearing and denied his motion.
So what I did is I moved to reset the hearing based upon the fact that Judge O'Brien couldn't decide the case because of the fact that he had received money from L.A. County, had not disclosed, number one, he received money from L.A. County, which was illegal under the Sturgeon decision, and under SBX 211 it was affirmed to be criminal. He had not, and he also, by receiving that, he violated Canon 4D1. He did not disclose it, which violated Canon 3E2. He did not disqualify himself, which violated Canon 3E1 and also the Code of Civil Procedure section 170.1 small a 6 big A III. And everything that he did was null and void because all of this goes back to the point in time when he was appointed and did all of these things because he'd received the money long before then, and he had retroactive immunity from criminal prosecution, civil liability, and disciplinary action under California Senate Bill SBX 211. So I said, he's out. We need a new judge. So I went in and I set a hearing to renew my motion to void and annul everything that Judge Yaffe did, saying, I need a judge who's clean. Go find me a clean judge.
So now on March 10th, Supervising Judge Burley will have to determine how he will deal with Dr. Fine.
Now this presents a real problem for the supervising judge. Supervising judge is Judge Burley. I have put in a request at this point in time with the county to find out how much money Judge Burley has received. And in addition to that, as people realize that almost every judge in LA County has received money, so they're either going to have to find a judge that didn't receive money in LA County, which there may not be anyone, which means that they'll have to send the case out to another county. Or if they give me another judge in LA County who's received money, I will just show how much money that judge got, and I will keep going if I have to go through all 430 judges of LA County until we get a judge who has not received the money.
From Dr. Fine's investigation, we've learned that Judge Burley has received over $637,000 in illegal payments from LA County. This will be an interesting hearing. Will Judge Burley also recuse himself? Will the court insist on a change in venue? Just last week, LA Superior Court Judge Henry J. Hall chastised the Bell City officials for taking what he claims are illegal salaries, while the judge himself is enjoying illegal payments from Los Angeles County. This struck a nerve in Dr. Fine. He sees it as the same circumstance that he is facing on March 10th.
This judge does not have the right to sit as a judge. And I say this in the interesting way, even though he has received immunity for having received the money and immunity for disciplinary action under Senate Bill SBX 211, what he doesn't have is he doesn't have immunity to be able to sit on the bench. Because Senate Bill SBX 211 did not give him immunity from obstruction of justice of sitting on a bench when he has taken money from a party who is likely to appear in front of him.
This is an important point that could have federal ramifications, as Dr. Fine explains.
SBX 211 has given them retroactive immunity from the prosecution of taking money on the state level, but it didn't give them any immunity from the federal crime of violating the intangible right to honest services. So all these judges could be prosecuted federally if either the Attorney General had the guts to do it, or our present U.S. Attorney here in Los Angeles had the guts to do it. So far, neither of them have shown courage in that particular matter. If either of them showed any courage, our system would be cleaned up in a minute.
Dr. Fine has been criticized for his uncompromising stance on this issue. He is confident that eventually he will prevail and refuses to give up, as demonstrated by his enduring 18 months in solitary, coercive confinement in the LA County Jail. It is a test of wills.
It's a test of corruption on the one side, which is on the judge's side, and the county supervisors, who are continuing to take approximately, at this point, it's probably up to $25 million a year of our tax money and illegally paying it into the judges, versus the will of the people, which I represent, to have an honest judicial system. Sooner or later, we will win. We will win by one of two ways. Either the judges will give in, or they will pass on. It's going to be one of the other. They can't stay in office forever. We, the people, will be around forever. So when you look at the long term, we will win.
We want to know what you, the viewers, think. Please respond to our survey and be sure to leave your comments below. Do you think that Dr. Fine should continue fighting to stop the illegal payments to the judges? Yes or no? Richard Fine has identified a real-life Chinatown scenario here. His well-documented indictments include a powerful Hollywood movie star, multi-millionaire developers, and the highest-level officials in our judicial system. We have the document here for you to read right on this website. Click on the link below to read this revealing 10-page court document, and please be sure to leave your comments below. I'm Leslie Dutton. Thank you. We're going to take a quick break right now, and when we come back, we'll show you our second video block in this series. We'll be right back.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At FullDisclosure.net, we want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show. And if you can't watch us on your local cable station, streaming video of complete shows when you want them. FullDisclosure.net, when you need to know the news behind the news.
Welcome back to Full Disclosure and our video blog special. Here's our next video blog.
And I'll just knock them off, judge by judge by judge by judge. Sooner or later, we're at 425 now. Sooner or later, we will be down to 0.
Dr. Fine is moving forward in his effort to restore integrity in the California courts by having the ruling of Judge Yaffe nulled and voided.
Since our last visit, the motion to null and void, as you know, was taken away from Judge Kuehl and was sent to Department 85, where Judge Chalfant is now sitting. Doing the research on Judge Chalfant, I found that commencing in 1998 through the present, Judge Chalfant has received approximately $608,000 in illegal payments from LA County.
As a prosecutor, Deputy District Attorney Steve Ibsen is also concerned about the illegal payments to the judges.
The problem in the judicial payments is that the bias is there for everyone. The danger of the bias on behalf of everyone is now you have the county making payments to you as an employee, and then the county is also the litigant. When you have the employer paying the judge, how can the judge make the decision as to the employer? And there's an obvious bias there. And it's a clear one. And any attorney who's been in court regarding bias needs to see there is a problem here. And how it manifests, it doesn't mean that every judge is corrupt. It doesn't mean every judge is dishonest. But it is a pressure and the appearance of impropriety that attorneys often speak of. even the appearance must be absolutely avoided. And the pressure that it could create on any bench officer, is, even without the suggestion by the county, but if the county ever suggested, we might not be able to make those bonuses if this ruling doesn't go our way. And I have no reason to believe that ever happened, but if that suggestion was ever made, it's very powerful pressure on a ruling of a bench officer that needs to have no consequence to what he does. A judge and the judges I've appeared in front of, there's never any pressure on them other than doing what they think is right. And if part of what's at stake is, will I get my bonus, and will 600 fellow colleagues get their bonus if the county's mad at us, if that pressure is there, or the possibility, the danger of it distorting judicial rulings is disturbingly significant.
So Judge Chalfant quickly got out of the way.
When Judge Chalfant received those papers, Judge Chalfant, within about 24 hours, he accelerated the hearing date of the motion from the 27th of April to April 18th, and immediately recused himself and sent the papers back to Department 1 to have the motion reset in a different department. I called Department 1 right before we've gone on the air, and Department 1 said that the papers are now sitting on the desk of Judge Kuehl, who has not decided what to do with it. They've been on her desk since approximately the evening of the 18th of April. What goes around comes around. Judge Chalfant was one of the first judges in this entire saga.
Dr. Fine has been fighting the illegal payments for over a decade. For his efforts, he's been attacked financially and professionally when he was disbarred by the judges.
You know, in 2008, the Sturgeon case came down and showed that the money was illegal. And this Sturgeon case came down before I was disbarred. So the State Bar knew that they were committing a fraud when they disbarred me for having brought this case in 2002. Chalfant was the judge. So now we've come full circle. Chalfant is now sitting on the Marina Strand case, and now I'm hitting him again with the amount of money that he received. This time when he saw it and he knew that I had him nailed, and he had a choice. He could either recuse himself or he could lose his judgeship and go to jail. He made the election. He elected to recuse himself immediately. And this now stands as a precedent for every judge that is faced with a lawsuit in which L.A. County is either a party, or you have L.A. County as a witness, or you have L.A. County involved in the suit. These judges now know that they can lose their judgeship, they can go to jail, or they can recuse themselves. We've just had a very, very major victory showing that the 473D motion is going to work, that the judges now know that they have to recuse themselves.
So 6 down and 424 to go. You can view his latest court filings, the judge's recusal, and the auditor's report on how much money Judge Chalfant has received from L.A. County. They are all available on the links below. Please let us know what you think. Do you think Dr. Fine will have to knock them off one at a time, or will he soon get justice? Please leave your comments below. I'm Leslie Dutton. Thank you.
Another one bites the dust. Another one bites the dust. Another one gone, another one gone, another one bites the dust.
When we come back, we'll show you the third and last video segment in this video blog special. We'll be right back.
For the news behind the news, wherever and whenever you want it, go to fulldisclosure.net and get programs on topics affecting you, weekly updates and alerts on hot topics, video streaming of Full Disclosure episodes. It's award-winning, hard-hitting, corruption-fighting news coverage. And it's only available at fulldisclosure.net. fulldisclosure.net, the news behind the news.
Welcome back to Full Disclosure and the last segment of our video blog special. At the conclusion, we will invite you to add your comments to the discussion. Here's the third program in our video blog special. Dr. Richard Fine holds a Ph.D. in international law and was a former U.S. prosecutor in Washington, D.C. He challenged and refused to respond to Judge David Yaffe's illegal order and was incarcerated in the Los Angeles County Men's Central Jail for over 18 months, where he was held in solitary, coercive confinement. Finally, Judge Yaffe relented on Friday evening, September 17th. Dr. Fine is now a free man. He gave Full Disclosure this exclusive interview in his home 2 days after his release, where he described the conditions of his confinement.
The lights were on 24 hours a day. Out of the 18 months, there were only, I think, 3 days that the lights went off at night, from approximately 12 o'clock at night until 5 in the morning. And the cell was freezing. I mean, that cell was in the 50s at some point in time. And because the building was so old, parts of the building would freeze and the other parts of the building were overly heated.
Hygiene conditions were very Spartan.
You get a shower every other day. There's no such thing as a daily shower. And in my case, because I was to be kept separate from everyone, I always was able to, I showered alone. You know, you always hear these jokes about the jail and everything else, don't drop the soap and these types of things. I never had to face any problems like that. Every once in a while, they used to forget me in the shower. And normally a shower might be anywhere from 10 to 20 minutes or so. Sometimes they would forget me. I might be in there for an hour, 2 hours.
The conditions were barely tolerable.
I was in that cell 24 hours a day, unless there was a visitor that came, and the visiting days were Thursday through Sunday, and you could get one visit. You could have up to 3 people on that one visit coming in at the same time, but only one visit per day.
Treatment of jail inmates is established by the color of their jumpsuits.
In the beginning, I was supposed to be in a red outfit because I was contempt of court, but they didn't have any red outfits, so they had me in an orange outfit, and I remained in the orange outfit for, I'd say, approximately 16 months. And then suddenly they brought up some gang people who were breaking gang injunctions, so they found some red outfits, so I went from orange to red. My feeling is I suddenly became déclassé because the orange outfit were the high-class felons. And so there were the murderers, attempted murderers, dope dealers, and everything else. So it's pretty classy in an orange outfit in the jail. Red outfit, you're just a contempt of court person unless you're a gang member that's broken a gang injunction. And you take a look at me, I'm not looking like your typical gang member unless you have the gang members of the over 65 guys. So I might have lost some status.
Over the hill gang.
The over the hill gang, yeah.
Being that torture is not allowed in American jails, Judge Yaffe had to resort to more civilized ways of persecuting Dr. Fine. During his first few weeks in jail, Dr. Fine was first placed under the humiliating status of suicide watch. After a time when he refused to relent, the jailers gave up and put Dr. Fine in a regular cell.
So then they shifted me to the final cell that I was in that didn't have a desk or a chair, but it did have a telephone. And believe me, I was very willing to sacrifice the desk or the chair for the telephone, because having the telephone was something that allowed me to communicate with the outside and to get the briefs done and everything else. Otherwise, I would only be allowed to use the telephone for maybe an hour a day or something else in this order. I would have never been able to have written my briefs or been able to done the petitions or anything else.
We asked Dr. Fine if he was tempted to give in to Judge Yaffe. He immediately said no, but there were difficult emotional times during his incarceration.
I think the darkest day was the day that I found out that the U.S. Supreme Court had turned us down. In that point in time, that I fully recognized that the corruption, when I use the word corruption, not only the corruption of the payments, but the attitude of the abuse of power to allow the corruption to exist and stay within the system had gone so far that the entire system was undermined.
Learning that the entire United States judicial system is a series of good old boy clubs that protect each other's follies would dishearten most people, but not Dr. Fine.
But that day that ended up with greater resolution, because you have a dark day and then you come back and you say, well, let's recognize it. If this is what it is and it's this bad all the way up, we've now shown it, we've now proved it, and we go on from there to fix it. I can sit here today and tell you, based upon every brief that was filed and based upon every Supreme Court decision, that I should have never been in jail, and that every court avoided their responsibility and did not follow the law. And I can say that with true certainty. Very few people can do that. But now, because of what we have done, because when I say we, I'm referring to the team and myself, because this was truly a team effort, because what we have done, we have shown that to be true. And there is nothing that a U.S. Supreme Court justice, a Ninth Circuit justice, a U.S. District Court judge, a California Supreme Court justice, a California Court of Appeal justice, or a L.A. Superior Court judge can say to the contrary. We've shown this to be the case. This is now a proven fact.
When criminals are convicted, they are sentenced to a specific period of time. Sometimes they're punished with solitary confinement. Dr. Fine was never charged or convicted of a crime, and yet he was sentenced to an indefinite term of solitary coercive confinement. After a year of this unrelenting punishment, most people would be worn down and broken. Dr. Fine never wavered. How was he able to maintain the mental fortitude to never give up, we ask him.
The way that you do it is that you become very spiritual. By being a spiritual person, you basically end up believing that no matter what happens, it's all going to turn out right. It's not going to turn out, may not turn out the way you may think should be right, but in the totality of events, it will turn out right. So it's a real lesson in learning we don't control what happens, and just keep doing the very, very best that I had, because I didn't have control over Yaffe, I didn't have control over the Supreme Court or anything else. But I had the basic belief, and it was confirmed. There is someone upstairs taking care of me. And not only taking care of me, but showing that we will actually, we as a country will actually prevail. Everybody's been fighting to keep me in jail, and suddenly I'm out. You know, it's very interesting that following the procedures didn't do it. But something happened to Yaffe to make him admit that I was in there from the beginning as a deterrent to any other attorney. I mean, imagine the impact of that, to come out 18 months later to say that this had nothing whatsoever to do about the case, about paying money to the county, about revealing assets or anything else, that this whole thing, bottom line, one little sentence, I was there as a deterrent. I acted as a deterrent to any other attorney who would think of challenging them on this set of facts. And what is this set of facts? The judges are getting paid off. That's what it was.
This is just a short preview of a 3-hour interview. Dr. Fine was disbarred and his law license taken from him as a part of the persecution, and his home is in foreclosure. Friends of Dr. Fine are setting up a fund to restore Richard Fine. If you would like to contribute to the fund to help restore Richard Vine and our judicial system, please call us at 1-800-867-7777 and we'll tell you how you can contribute. I'm Leslie Dutton. Thank you. This concludes our video blog special. We're interested in what you, the viewers, think. If you would like to answer any of these questions posed by these video blogs, or if you'd like to make comments, please call our Full Disclosure Town Hall number at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
You can watch this program in its entirety as a Full Disclosure subscriber, or you can purchase the DVD on our website. Full Disclosure will continue to bring you the news behind the news.